You have heard the evidence presented in the case. It is now this court's duty to instruct you on the law which applies in this case. It is solely this court's function to explain the law that applies in this case and how you are to apply it. It is your obligation to accept the law as the court states it. You may not choose to follow some instructions and ignore other instructions. They are equally important. You are the sole judges of the facts. It is your duty to find or determine the facts. You are to recollect and weigh the evidence and form your own conclusions concerning the facts. You may not go outside of the evidence presented in court to determine what the facts are. You may not resort to guesswork, conjecture, or suspicion. You may not be influenced by personal likes or dislikes, prejudices, or sympathy. You may not be influenced by this court's actions during the trial or the comments to counsel or objections by counsel. You may not be influenced by the court's questions to witnesses. You are not to consider this court's actions as an indication of its opinion as to how you should determine the facts. If during the instructions the court refers to any evidence, it is only for the purpose of clarifying a point of law or a point of illustration. The court does not intend to emphasize some evidence and downplay other evidence. If the court's recollection of the evidence does not match your recollection controls. The defendant justly relies upon you to consider carefully her claims and to consider carefully all of the evidence. The defendant also relies upon you to find her not guilty if the facts and the law require such a verdict. At your hands, the defendant rightly expects fair and just treatment. At the same time, the state of Connecticut looks to you to render a verdict of guilty if the facts and the law require such a verdict. The law prohibits the state's attorneys or defense counsel from giving personal opinions about the defendant's guilt or non-guilt. It is not their assessment of the credibility of witnesses that matters, only yours matters. In this case, as in all criminal prosecutions, the defendant is presumed to be innocent unless and until proven guilty beyond a reasonable doubt. The presumption of innocence continues with this defendant unless you determine, based on all of the evidence considered in light of these instructions after deliberations, that the defendant is guilty beyond a reasonable doubt. The presumption of innocence applies individually to the crimes charged. The presumption may be overcome only if you are satisfied after deliberations that the state has proven the defendant's guilt to the crimes charged beyond a reasonable doubt. If you conclude that the presumption of innocence has been overcome beyond a reasonable doubt, then it is your duty to render a verdict of guilty on that count. The state has the burden of proving that the defendant is guilty of the crimes with which she is charged. The defendant does not have to prove innocence. This means that the state must prove beyond a reasonable doubt each and every element necessary to constitute the crime charged. Whether the state carries its burden does not depend on the number of its witnesses or on the amount of the testimony, but on the nature and quality of the testimony. One witness's testimony may be sufficient to convict if it establishes all of the elements of the crimes charged beyond a reasonable doubt. Now, you have heard the term reasonable doubt. The court will instruct you now on its meaning. We will first explain what is not a reasonable doubt. It is not a surmise, a guess, or a mere conjecture. It is not a doubt raised simply for the sake of raising a doubt. It is not hesitation springing from any feelings of sympathy for the defendant or for any other person affected by your decision. Reasonable doubt is a real doubt, an honest doubt, a doubt that has its foundation in the evidence or lack of evidence. It is a doubt that is honestly entertained and is reasonable in light of the evidence after a fair comparison and careful examination of the entire evidence. When thinking about the term reasonable doubt, concentrate on the word reasonable. Proof beyond a reasonable doubt does not mean proof beyond all doubt. The law does not require absolute certainty on the part of the jury before it returns a verdict of guilty.